Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mojolaoluwalivingstones. Today we want to talk about a very important aspect of law, especially as regards property transactions or property law in Nigeria. We want to talk about power of attorney. Power of attorney. Now I know that for attorney, a lot of people say things like Anthony or Attorney or whatever it is. That's not the pronunciation. It is attorney. Attorney, just as in Attorney General. So power of attorney. What is power of attorney? Power of attorney is a document, usually but not necessarily always, under seal, by which the owner of an estate or an interest in land authorizes another person called the donee, he now being the donor, to act on his behalf. And usually those powers that can be exercised by the donee are spelled out in the power of attorney by a deed poll. It is done by a deed poll. By a deed poll means that the owner of the property will be the only one to execute the document, spelling out all the powers that he wants the donee to exercise on his behalf. And it can also be executed by both parties, in which case it will be by a deed indenture. So that's basically what power of attorney is. That is, I have a property, but maybe I'm busy, I'm out of the country, or I'm otherwise engaged or incapable of exercising those powers. I now sign a deed poll, a document under seal. It might not be under seal, but essentially I'm signing a document wherein I'm listing out the powers that I have over that land or property, and I'm now putting someone's name as the person that can lawfully exercise those rights on my behalf and for me. So usually the donee, that is the person that receives the power, can do everything that the donor can lawfully do. Yes. So like I said, it's usually for property transactions. So for property owners, land owners are the ones who usually exercise or execute the power of attorney, but it's not limited to them. Now, what are the powers that a donee of a power of attorney can lawfully exercise? Most of them are as follows. They can buy and sell land on behalf of the donor. They can collect rent, rates and what have you, fees on the property on behalf of the donor. They can actually sue and be sued instead of the donor. That is, they can take matters to court, and they can be taken to court instead or in place of the donor, on behalf of the donor, and they can collect money on behalf of the donor generally. We must note, however, that a power of attorney can only confer powers on the donee that the donor can exercise lawfully himself or herself. That is, only the things that a donor of the power can lawfully do. Those are the things that he can authorize another person to do on his behalf. Now, if there are things that he cannot do lawfully, maybe because he's an invalid or is an infant, or is physically or mentally incapable under the law of doing such things, a power of attorney cannot come to the rescue. That is, he cannot empower another person to do those things on his behalf. Also, power of attorney can be executed by both parties, which would be a deed indenture now, like I said. If, for instance, we're trying to prevent fraud, or maybe it is coupled with interest, or there's a consideration given for the power of attorney. So usually power of attorney is in writing. It has to be in writing. Just to be safe and to cover all grounds, power of attorney must always be in writing. And then if it's power instructing the donee to execute a deed, the power of attorney must be a deed by itself. You know that any document authorizing someone to execute a deed must be a deed itself. So for the power of attorney to be binding, to be valid under the law, both the donee and the donor must be legal persons. That is, they must be people whom the law regards as legal entities themselves for the power of attorney to be valid. Now let's talk about the features or the characteristics of a power of attorney. I've said that it must be in writing. That's the first and important thing. Another thing is that it's an instrument of delegation. So it must be telling someone to do something on someone's behalf. Yes. So another thing is that a power of attorney does not transfer ownership. So even if the power of attorney is instructing or authorizing the donee, that is the person to whom it is addressed and on behalf of whom it's being executed, So even if the power of attorney is directing the donee to do things on behalf of the donor, it does not mean that the donee is now the owner of the property. Yes, so if I execute a power of attorney asking maybe a friend, a lawyer, an agent to collect rents on my behalf over a property, I am still the landlord, yes, and I'm still the owner of the property. It doesn't make them the owner. It just means that they are exercising my ownership rights on my behalf. So it's just delegation. Goes back to the second point. So that's the third point. Now, the fourth point is that where the power of attorney is given to execute a deed, it must be a deed itself. So that means the power of attorney does not necessarily have to be a deed. It should just be in writing. Yes, but if you are authorizing someone to execute a deed on your behalf as the donor, you have to prepare a deed, either a deed poll or a deed indenture, that is either signed by you alone or you, the donor, and the donee. That's the fourth point. The fifth point is that power of attorney must be from a legal person to another legal person. So both the donor and the donee must be legal persons under the law. They must not be infants. They must not be mentally impaired people who are not regarded as persons who can act on their own under the law. They must be people who can legally act on their own under the law, because the power of attorney will not cure, a defect, a lawful defect, or a defect in law. The power of attorney will not cure a defect. Another point is that once it is given or issued or executed, the donee can now act on behalf of the donor without resort. The donee can now act on behalf of the donor without having to resort to the donor. For instance, if you give someone a power of attorney to manage your property, and then as the donee, they decide that they want to eject tenants from your house, they do not have to come and tell you that, oh, I want to eject this tenant, because they're acting as if you are the one acting. Yes, so they can lawfully do that, do everything that you can do under the law. Now, it's funny because there was a time that I think it was a mediation case I handled, or maybe I read about it, but I know that there was a time that a donor sold the house after he had given a donee the power of attorney to manage that property and to sell or not to sell it. So he sold the house. The donee then went to court suing the donor for exercising his ownership rights over his property behind his back. It's very funny, I know that I think the important thing is that both the donee and the donor must have an agreement of the mind at all times. That is, they must not be at loggerheads. But essentially, if you are giving someone power of attorney to do something, it follows that you should inform them if you now want to exercise those powers yourself. Because giving them those powers do not mean that, because giving them those powers does not mean that you can no longer exercise it. But to avoid conflict of interest, there should always be an agreement of the minds if and when you decide to exercise the power. Because the law is still regarding them as being the lawful or rightful person to exercise those powers since you have delegated them. But it doesn't mean that ownership now vests in them. So it might be very funny for someone to sue for such a in such instance, but it did happen. Now, power of attorney can be revocable or irrevocable. It depends on what you agree with the donee and what you as the donor want. How does the law or the courts view power of attorney? Now, the way they view it is as a delegated power. So this means that they do not see you, for instance, if you have been given power to sell a piece of land, they do not see you, the court will not see you as the owner of the land, but just as someone whom the owner delegated to sell the land on their behalf. Now, another thing important when the court is considering a power of attorney is that all the powers must be listed in the document, that is the deed poll or the deed indenture. All the powers that you want a donee to exercise must be listed. So if a donee goes outside of those powers, he or she will not be protected by that deed that you've executed or by the power of attorney. So they have to answer on their own for things that they do outside of the powers that the power of attorney confers on them. Then another thing that is like it is that a donor must be very careful to list out all the powers that you want a donee to exercise. So as you cannot, as the law will not protect a donee that exercises more powers than is given, the law will not also protect a donor who is claiming or suggesting that a donee should have exercised a power that was not expressly given to them. So a power of attorney, the list of the powers to be exercised must be exhaustive on the face of the document, transferring the power from the donor to the donee. However, you can make a power of attorney specific or general. So a general power of attorney will allow a donee to exercise or to carry out all lawful rights or duties that are associated with the management of a property, for instance. But a specific power of attorney could say that to collect rent alone. But if it says to manage the property, that means that the donee, that is the person that receives the power, can do everything that is incidental to the management of the property, such as, carrying out repairs like the landlord would have, renting it out to people, ejecting tenants, paying rents, rates and taxes on the property, and all incidental matters. But if it's a specific power of attorney, it could have said, to carry out repairs on this property or to collect rent. So if it's specific, the donee can only exercise specific powers. But if the power of attorney is general, then the donee can exercise general powers, things that can be deemed or viewed as incidental to management of a property, for instance, or whatever the power of attorney is asking the donee to do. Power of attorney can be revoked at any time, so long as the donee has not exercised the power. For instance, if you have given someone a power of attorney, for instance, if a donor has given the donee power to sell his property, if he has not sold the property, the donor can revoke it at any time, like the case that I mentioned went to court now. So that would come up. If you have not sold the property, I, the owner, can decide to sell it at any time. That means I've revoked, the power of attorney. But I think the important thing is just communication between parties. But a donor can revoke the power of attorney as long as it's not coupled with interest or given for a consideration, and as long as the donee has not exercised that power. So a donee can be the power of attorney can be revoked just the way that it is issued. So if it's a deed poll, you have to revoke it by a deed poll. If it's a deed indenture, you have to revoke it by a deed indenture. And if it's just in writing, you can revoke it in writing by merely writing to the donee that, okay, we are revoking these powers. So that's probably one other thing that happened with the court case that I mentioned earlier. Probably the donor did not even tell the donee or execute any document, as was in the case of transferring the power, to let them know that the power has now been revoked. So the power must be revoked properly. The length of time power of attorney is executed for 12 months, within which it's not revocable. But then the length can be extended, and it can be according to the wishes of the donor. But I think the important thing for power of attorney really is that there must be clarity. That is, the donee, the donor, and third parties, must be able to understand by merely looking at the document executed, whether by a deed or just in writing or under seal. They must be able to understand that it's a power of attorney. This is the donor, this is the donee, these are the powers granted for this time. It's revocable or it's irrevocable, it's coupled with interest, it is given for consideration, that is for money, or it is not. So those things must be clear on the face of it. So power of attorney can be revoked, by law, expressly or impliedly. So like I earlier mentioned as well, if a donor goes ahead to exercise the right after giving the power of attorney to a donee, that means that the power of attorney is revoked impliedly. Now, expressly is by executing another deed or making it in writing, or by putting it under seal that I hereby revoke the power of attorney granted to you so and so present to do so and so, and all of that. And then it can be revoked by law. By law would mean that, for instance, the owner of the property is no longer the owner of the property. There's nothing to exercise the power over, so it's already revoked. For instance, maybe some people went to court and the court declared them the owner, the rightful owner of that property, over which a donor has given a donee the authority to exercise powers. There's no subject to exercise the power over again, so it is already revoked. Also, by bankruptcy, if, for instance, in bankruptcy, the property in question is lost, or maybe it's liquidated, in that instance, there will be nothing to exercise the power of attorney over again, and so it's been revoked by law. Another thing to note is that if it can be established that the power of attorney was executed under fraud or duress or undue influence, that is, if the donor, for instance, unduly influenced the donor to grant the powers, or any hanky-panky is discovered in law, the power of attorney will be revoked. That is, it will be invalidated rather. The power of attorney will be invalidated. So that's essentially all you need to know about power of attorney. Aside the revocation by law, that is, if the owner of the property is no longer the owner under the law, if the donor dies or becomes a lunatic or becomes bankrupt, it does not automatically revoke the power of attorney, except the power that was donated by that person, except the property over which the person donated the power of attorney is no longer their rightful property. That is, if their ownership of those things does not terminate by death, lunacy, or bankruptcy, the power of attorney does not also terminate, or is not also terminated. So we have to be clear. Now, I said that if, for instance, the property is liquidated, or maybe it is sold to realize a debt sum, or maybe it is sold or called in by a creditor to realize a debt sum in the process of bankruptcy or what have you, the power of attorney becomes invalid, or stands revoked. The power of attorney stands revoked. That's because the ownership is no longer vested in the donor. But if the ownership is still theirs, whether they have died, have become a lunatic, or bankrupt, the power of attorney will still subsist and can still be rightfully exercised by the donor. So this is all I want to tell you about power of attorney. There are a plethora of cases, talking about power of attorney, Abina, Farat, and a few others that I'm going to list in the description box. Please read them up, and I will see you in my very next video. To-dos.